Good evening. This is Rahul Reddy live from Houston, Texas. Every Tuesday from 5 to 6 p.m. Central Time, we present immigration updates. Along with me is my business partner, Ryan Wilk. He's been associated with our firm from 2012 to right now more than 10 years. He looks very young, but he's been senior. He's a partner in our office. Ryan, what do we have to discuss today?
A couple topics we'll get off. I think if you've been reading the news or anything lately, you've been seeing the budget bills passed around the House and the Senate, and whether any immigration bills, any provisions are going to come through. Looking through it, nothing that's come through that's very helpful for us. And by helpful, I mean, giving any benefits to the immigrants. It looks like most of, I would say 99% of everything is more money for immigration judges, more money for deportations. By and large, I think that's what the news wants to see, and so we didn't get this comprehensive package like we've been hoping for maybe the last 30 years.
So do we have anything about for the people who are unauthorizedly working in the United States, they can get the insurance benefits, but nothing for the legal immigrants?
Yeah.
No, we haven't seen anything about the per country quota limit taken over.
Nothing.
We haven't seen any comprehensive immigration legislation. No, not counting the family members. Nothing came out in this bill, but still, it went to the desk of the President Biden, and he's expected to sign this bill right now. And that's 1.2 trillion. That's a lot of money. So until September of 2023, we won't have an immigration offices closures, at least based on this budget. So the money has been allocated to immigration, but no such benefits to the employment-based immigration. More things that are not related to the employment-based immigration.
And just one point that I'll make before we hop on to the next topic is I've been talking with a lot of Ukrainian clients, and they're asking kind of, will my TPS and all these sort of things be extended? And my response was, we really need to wait for September 2023 to see any action. So I'm hoping that across the board we see some sort of immigration action, whether it's these small piecemeal fixes or something different, we don't know. But if I'm going to hold my breath for anything, it would have been for the fiscal year coming rather than the fiscal year that's passed. So that's just my thoughts.
Yeah, also, Ryan, what I noticed is that when Biden administration came in, the total of people who were eligible for the temporary protection status, that means there's people like Nepal and other countries like Central American countries, those are eligible for the employment authorization, even though they are legal or maybe not legal also. That increased from 400,000 to all the way to 900,000 only in the past 2 years. So do we expect anything coming in the next 2 years? Now, for the first 2 years, the House and the Senate was with the Democrats, but they couldn't come anything in the Congress. So the administration unilaterally allowed some more countries, some more people to eligible for the people to get the employment authorization. We haven't seen any legislation done on the DACA, which was actually an administrative thing. They didn't went through the Congress to issue the employment authorization. About 500,000 people who are having employment authorization. And there are 1 million more people who may get benefit if the DACA passes through the House and the Congress. It didn't happen. Do you expect any administrative changes coming in the next 2 years?
No, two quick points. We saw this jump, Rahul said, from about 400K to 900K, and that's typically the Ukrainians and then the Afghan refugees, I'll just call them for lack of a better word.
Some Central American.
Yeah, true. Now, will we see the DACA push forward even more? I don't see that program being strengthened. The Democrats are probably going to stick their heels in and say, this is something that we want to support. Republicans have pretty much consistently been across the board saying, we don't like this. We want to see a legislative fix. Well, guess what? You guys are in control of the House now. Let's see this legislative fix. But I think what you and I talk about a lot, what our office talks about a lot, is these documented dreamers. People, kids whose parents are in the green card queue and are going to age out before anything comes. Now, I think we do see a lot of bipartisan support on trying to find some solution for these undocumented these documented dreamers. What the fix will be, your guess really is as good as mine.
One thing I believe is that since the House is going to change, though, Biden, he looks very simple, very cute, very nice, seems to be doing much action, but actually when it comes to the action, he's a very active guy. I have seen him the way he pulled out the army out of Afghanistan, where all previous administration tried to do it, they couldn't do it. He did it. I think so. He's going to show his true face now, since the House is going to be going on January 3rd to the Republicans. He's going to make a lot more administrative changes. The one that I would be looking forward from the administration is not counting the family members. That's one thing, and probably using the unused immigration green cards that went out, almost like 250,000 green cards. No, I'm sorry, about 300 plus thousand green cards that were not used for the employment can be given back to the employment. I do expect Biden administration to make some administrative changes in the coming months, because this guy, I've seen him. It's been like 25 years I've been observing him. He's not. He's not. He takes very hard decisions and is very firm on what he does. He has given chance to the House and the Congress to act. They didn't act. Now I think so. He's going to act. That's my opinion. Now there are a lot of people asking questions, especially those people in adjustment of status. We're moving to a different topic, guys, where people who have traveled and advanced parole, when they come back, the $1 million question that comes is that, let's say, for example, their H-1B validity is there until 2024, and they traveled and they come back on, let's say, March of 2022, and they come back on advanced parole. Are they on H-1B? Are they on advanced parole? Well, the USCIS says that if your H-1B is still valid, or if your H-4 is still valid, you can extend the H-4 or H-1B, L-1 or L-1B. You can transfer the H-1B to a different company. So what I would say is that if you can walk like a duck, you can talk like a duck, you can smile like a duck, you give an egg like a duck, you probably are a duck. So that means that I consider them to be an H-1B. Now, of course, some of the people will say only at the time of extension you'll be considered, or at the time of transfer you will be considered as H-1B. But I would say that every time you're considered to be an H-1B. Now there's another thing a lot of people are concerned about as soon as they enter into the country, Ryan, is when they enter into the country, they only give an I-94 until 1 year. And people are panicked. What's going to happen after 1 year? Am I going to, my I-94 states that I'm a parolee, I came in advance parole, and it expires in 1 year, and it's expired. Is that going to be a problem? Absolutely not a problem. Absolutely not a problem. If you extend your H-1B, it's not a problem. If you don't extend your H-1B, it's not a problem. If you extend your I-131, which is advanced parole, it's not a problem. If you don't extend your advanced parole, it's not a problem. Absolutely. When you're in adjustment of status, you traveled and you came back on advanced parole, you can stay in United States even if your I-94 expires for the employment-based immigration. Please don't take my I-94 expiration in a common meaning. This is only specifically for the people who have traveled and come back in advance parole, and only those employment-based adjustment of status people, not other people. So they can stay. Don't panic and call our office and say, Rahul, my I-94 is expiring. It's okay, calm down, you're okay. This is only for the I-131 advanced parole. For H-1B, H-4, if their I-94 is expiring, please contact your lawyer. You need to extend it if you're a non-immigrant status, your I-94 expiring based on the I-797 or based on your passport, you better contact your lawyer. It's very important. But when it comes to advanced parole, don't get panicked. And we have a lot of people coming into a Zoom conference call. If you guys know, we do have a daily Zoom conference call. You can come and join anytime to ask a question. Simple question, Rahul, my I-94 expiring, what do I do? Every day we have a Zoom and the link is provided for you there. Any comments on that?
No, I think maybe DHS could change it to a DS notification.
Yeah.
Giving a date, that way.
Very similar to the F1 visa people, that would be nice. But anyway, we are there for them to help.
Yeah.
We're there every week. We're there every day. If you have simple questions, come there. If you have any, if you can wait for Tuesday evening, please visit to us. A lot of questions come on these B2 extensions, Ryan. Parents coming to United States, and the culture of the India and the culture of United States is quite different. I mean, when parents come to visit us, whether my wife's parent or my parents, they visit us for 6 months, and they stay in our home. And
I don't know if my wife would like my mother or her mother-in-law coming for 6 months at a time.
Well,
like you said, different cultural.
It's a different culture. Yeah. Yes, you're right. Yeah, and same thing. If my mother comes in, she stays with me for 6 months. If my wife's mother comes in, she stays with me for 6 months. We tolerate. Yeah, that's how we have grown. Of course, when it comes to you, they don't stay for a night. Even if they are from the out of city, they may stay for 2 days a weekend, maybe stay in the hotel. I don't know. That's how the culture is. Now the question that comes, Ryan, is that now they want to extend it beyond the 6 months.
Yeah.
And that is where the problem comes in, the cultural and a lot of other things. As Ryan was pointing out, that if his mother comes in and stays with his wife won't accept him. Well, his wife is not American. Well, from the descent, maybe she will, but I don't know. He doesn't know that yet. They live in the same town. But so when you apply for the extension of the B2, I recommend, if you can avoid it, avoid it. One of the main reasons is that they want your parents to visit you, not stay with you. When I mean stay with you, doesn't mean that they can't stay in your home. That's not what I meant. That's a little bit cultural difference between Rayan and me. That's not what I meant. Was to stay beyond 6 months with you and visit India. Let's say they stay here for 9 months, 3 months in India, come back, 2 months in, 10 months here, 2 months here. It looks they are more staying in United States and visiting. It always becomes a problem. One other problem is that recently with biometrics, when you apply for the B2, the biometrics, they have to get the biometrics done. And by the time biometrics done, it may almost take 5 months or 6 months. Your parents want to travel, your parents may be considered to abandoning the B2 application. And also if the B2 extension gets denied, though, either it's abandoned because you traveled before the biometrics happened, or it's been denied for other reasons, though. The problem here is that once a person stays unlawfully in this country for 1 single day, the passport visa is considered to be invalid. I'll tell you an example of it. Let's say your parents are visiting you and they came in July 2nd week, okay? And then they allowed to stay until December 2nd week, which is 6 months. So let's say if the I-94 expires on December 15th and they stay here until December 28th, what will happen to them? You know that, we all know that the passport stamping is not issued for 6 months. It's typically is issued for 10 years, right? So if they overstay the I-94 by one single day, the passport visa is considered to be invalid. That means that they cannot travel using that passport visa to go back and come back into this country. They will have to go to the consulate again, declare themselves that they have overstayed, and apply for the visa again, and then come back into the United States. So this danger is very common we see when people apply for the extensions. Extensions don't come on time, or they get their denial, or they leave the country before the biometrics happen. That's a big danger. We try to tell people to have them visit for 6 months, then go back, probably visit for 6 months. That would be better. But rather than overstaying or trying to apply for the extensions. Anything else, Ryan?
Not on the Bs. One last thing that we're seeing a little bit more of in the last 18 months or 2 years is this is for EB1Cs and people who are on L1 visas. And so we can call these kind of multinational managers, multinational executives, people who are working, for, say I'm working for Exxon, but I'm working at Exxon's outfit in India, for example. Exxon can bring me over to the US and I can work on an L1, or if they want to, they can get me what's called the EB1C.
What if all of a sudden Exxon is closed in India?
You'd have to tell me. I'm not too up to date on the.
No. What if the Exxon is completely closed in India? can you still continue working on L1 visa?
Yeah, and that's the issue that we're seeing pop up is, okay, my employer back home, they're shutting that office. How is that going to impact either my L1 or maybe my EB1C? And so we do have to separate our minds into whether we're talking about the non-immigrant L1 or the L2 visa, or if we're talking about the EB1C green card. So if you're on the L visa, let's think of it this way. There's the Indian outfit, there's the US outfit, and then there's the Mexican outfit. So there's 3 entities out there existing. The entire time you worked for that Indian outfit, and then you came to the US, and then yesterday you found out that Indian outfit closed its office. Is your L1 dead? No. The reason being is that there's still that Mexican outfit. It could be in any country. It doesn't have to be in Mexico. But there's some foreign entity out there that's operating. That's going to keep your L1 active. Now, let's say that there was never that Mexican outfit. There was just the Indian and the US outfit. Say that Indian outfit's dead. Is your L1 still alive? My answer to you would be no. Your L1's dead. Effectively, the day that that company in India wound itself down, and you're going to need to find some other visa option or depart the country, ASAP before you do accrue that unlawful presence. So that's the non-immigrant side. As long as there's some other country, some other entity in some other country operating that we can consider a qualifying relationship, you won't have any issues on your L1. Now on the other side,
you said L1A and EB1C is a difference there?
There's a difference with the EB1C. And so with the EB1C, let's really not worry.
EB1C is once you get an L1 visa or L2, you may be qualified for EB1C green card. That's what you were saying.
Yeah, exactly. And so it's a multinational manager or executive green card. And in the earlier example, we said that there's India, US, and Mexico that's operating. That's focused now on the green card side. There's the Indian side that you're working for. They transferred you to the US side, and now there's still that Mexican outfit that's operating. This Indian outfit, they shut down their operations. Maybe they were bought out by someone else. Does that impact your green card? Now we still have this Mexican outfit existing. Does that help us at all? The answer to that is no. What we look at is this Indian outfit that was bought out. Do they have a successor in interest? Did someone take on the rights or the liabilities that company was operating on in India? That's not a hard determination for the lawyers to make. It's not a hard determination to show USCIS. But if you are working on that EB1C, and that doesn't mean you filed your 485. It means you're either working on your I-140 or the I-140 is pending. If that Indian outfit drops out and there's no one else that maybe bought it who is considered this qualifying relationship, I would tell you that you probably are going to find yourself up against the wall on that green card case. Now, there's solutions and things like that, but you do want to be paying attention to who's that company I was working for abroad, and who is taking them over. And if there's no one, then the case is dead. If there's someone that's taking them over, I would tell you 90% chance you'll be fine.
So let's say, for example, Exxon India, Exxon USA, and Exxon Mexico is there. You're telling that if Exxon India closes out, the L1s can extend their visa status.
Absolutely.
But in the case of green card, if Exxon India is bought out by unrelated company, nothing to do with Exxon, in that case, they cannot get a green card at the EB1C.
Correct. Let's say Exxon sold it all off to Chevron. Chevron's a completely different company.
Different company.
Yeah.
But if Exxon India name has changed to some other name, but still Exxon controls it, then we most probably will.
Absolutely.
Okay. And especially this is a concern for the Russian nationals.
Exactly.
A lot of the companies that were operating in Russia, all of a sudden stopped. They just closed. I mean, no business done in Russia anymore. At least for some of the big oil and gas companies, this becomes very very burdensome. We normally advise people, hey, if you're eligible for EB1C, go and apply. Don't delay it. Who knows what's going to happen in a different country that you came from? So it's always good to do that. Anything else?
No, that's a roll.
Let's go to the live questions today. Ryan is the master in our office on the I-140 topic, though. All the lawyers, we have about 17, 18 lawyers, we all go to Ryan. I would say that Ryan, if he does more I-140s, I think so, he has done more I-140s in the past 10 years than any of the other lawyers in the entire universe. That's how many I-140s
Appreciate that,
he does it. All in day in and day out. So anything you have questions about I-140, EB2, EB3, educational qualification, ability to pay. He is the master of ability to pay. He has a very good Excel sheets that he prepared, puts in the numbers. Not lawyers are not normally that good, but he's very good in that particular thing. So he's the guy for you to go and get.
I appreciate that, Raul.
Okay, you get a question. on second question for you. What are the chances of EAD and compelling EAD visa extensions on H-1B layoffs and I-140 approval? Can we keep extending after 1 year? Can you extend the compelling circumstance?
So yeah, you can extend the compelling circumstance EAD. You can extend it. That doesn't mean that it will be granted. And so the sort of rule is that you can request the extension. You still have to prove some sort of compelling circumstance. It doesn't have to be the first compelling circumstance that got you the EAD. Things can completely change, but you do still need to prove to the government that you have this compelling circumstance. I would say if you file this extension, you are not entitled to work from the time your current expires until the next one's approved. During that time, you have lawful presence, so no issues there, but I would tell you that you don't have work authorizations. What's your chances? I would tell you have a 75% chance. These are discretionary. The same facts can be given to two different officers and each reach their own different decisions. And so we never say anything close to we guarantee this. But I would say if you go for the extension and you do have a bona fide, compelling circumstance, medical, things like that, I would be willing to bet that they're going to give you the approval.
Ryan has made a video last week at Reddy Neumann PC. You can go ahead. Please, if you have any questions on the compelling circumstances EAD, last week we made a video, and there is also a link that we have provided. If you fill the information out, Ryan is going to give a free evaluation if you are eligible for the compelling circumstances EAD. We don't charge anything. It's there last week. We have provided a link. Please try to fill that information. Questions that we related to what's going on with the family spillover that we got into this year. Is that going to be given to the employment base? Yes. Murli, it is going to be given to the employment base. But the problem is they do have more applications from India as of now to be given this year. And there's also a lot of demand from the rest of the world. So that's the reason why we're not expecting much jump. In fact, the prior dates have gone back. Is there a chance to go back? We don't know. But definitely we don't see much advance going on in the employment base because they do have too many applications already pending in there that may require all these numbers to be fulfilled.
We have a question here from Kumar. Received I-140 approval in EB1C, so that's similar to what we were talking about a few minutes ago about these foreign multinational managers and executives. The 485 was filed in July 2022 when the dates were current. The dates have since retrogressed, and it kind of asks what are the hopes of getting it in early 2023. Now, I'm not totally sure what your party date might be given the prompt here. It was a slight retrogression. I mean, there was a freeze, there was a wall that's put up, but it's not like it's EB2 or EB3 where we're looking, years and decades into the past. If anything, you're going to be a few months away from the approval, and so I would tell you that my gut feeling is that you stand a pretty good chance in 2023. I don't know if early is going to make you happy, but given how the way the dates are going, I would think EB1C should be available for you next year. Again, I don't know what your party date is, but the retrogression hasn't been that stark. And so keep your hopes up. You're pretty, the light's there. You're almost at the end.
I'm an F2. I-140 is approved in EB3. Is there a way I can apply for the EAD? My sponsor wants to start working for him as ASAP. Salim Nurani. I think so. I spoke with you in the Zoom call today. But if you're not the person, I think so. You're from Atlanta. But if my guess is wrong, excuse me. If you're from India, your I-140 has just been approved in EB3. The priority date is backlog a long time ago. But if you are from any other country other than China, the priority date is current. You can file an EAD right now. But when I spoke in the morning, you said you're from India. You said, your wife is a speech therapist. So we spoke, I think so. I already guided you all the things, but maybe it's my mistake. But if you're from Pakistan or any other country other than India, you can apply for the adjustment of status immediately and get an employment authorization, even though you're an F2 visa.
And Senthil on YouTube asks, my EB3 I-140 downgrade was approved in August 2022 through regular processing. Last week, the case status, I'm guessing through USCIS's case status website, says that the fee will be refunded. Senthil asks, what the status means? We didn't apply for the premium processing. I'll tell you frankly, I've never seen that fee will be refunded message. But one thing I will tell you is that you really have to hold a gun to my head, and I have to have no other choice before I believe the things that I see in that case status website. Oftentimes, it's either inaccurate or notoriously slow to come up to date. And so, if you are seeing these things, don't let it cause you too much concern. If you have this your I-140 attorney, perhaps you can contact them and they can reach out to USCIS just to see what the status is. But if the case was approved and you haven't seen what's called the Notice of Intent to Revoke, NOIR, I would tell you not to have any concerns. If the fees were refunded, hey, maybe you're getting a check in the mail and you can have some nice end of the year shopping. But generally, I would tell you not to have too many concerns, but do elevate it to either your employer or your I-140 attorney just for a double check. But I would say that you really don't have anything to worry about.
Mr. 4535 from YouTube has this question. I got my green card about 5 months ago. For some financial reason, the company that applied for the green card has not provided me, they have not provided me a job right now to join after the green card. Will that be a problem? It's only intention, though, that their intention to have you join. But because now financial reasons have changed, if they change their opinion on it, it's not going to cause any problem whatsoever at all for your green card, for your citizenship, or your travel, or anything, whatever you think. You are fine, your green card is fine, your citizenship is fine too. Vicky from YouTube has this question. USCIS has sent an RFP for my AOS application seeking supplement J. I have not changed the job since filing. Why are they asking for one? Vicky, just provide, don't argue with them. How do they know that you're still working for the same company? Maybe you're a software engineer. Maybe you're working as only Uber driver. You're not working as a software. How do they know that? You need to keep on telling them. Sometimes they will ask those questions. Hey, Vicky, are you working as a software guy? You just have to say, yes, sir. Provide me the letter. You just provide the letter. Don't argue with them. It's easy. Just take the 485J supplement, have them sign again. Hey, 485J supplement form has changed. Don't send the old form, okay? From December 23rd onwards, it's a new form. Send the new form. When they ask the 485J supplement, you give them what? You don't give them 485. You don't give them I-131. You don't give the employer letter. You don't give the paycheck. What do you give? When they ask 485J, you give them 485J. But the current form has changed. Given the current form, don't copy the same thing and send it to them.
There's one more point on that one too, Vicky. I'm going to assume, I'm going to guess that RFE you got came from a field office. Those field offices I'll just say, are notorious for sending the supplement J RFEs. Giving as much credit as I can to USCIS, I'm going to say that those field officers aren't as educated and up to date on what these supplement J's mean. And so really what they're doing is they're sending you a copy and paste job out of their manual just to make sure that they have everything in their file to approve your case so that they don't get yelled at by their big boss. And so if you're seeing this, don't worry about it. Like Rahul said, give the 485J. You can copy and paste your old one. Make sure it's the new form because they updated, I think, December 20th. But other than that, what you're seeing is very, very normal.
Yeah, and then as Ren is pointing out, these people have the quota. How many approvals you gave it, how many RFEs that you have issued. They have to give it to them. Oh, we have issued so many RFEs. Oh, nice. You get the promotion. That's what happens with the bureaucrats. So now they issued an RFE. The simplest RFE that you can ever see in the 485 application is 485J supplement RFE.
Maybe give the birth certificate, maybe give the medicals. There's very little thought that goes into that.
Yeah.
But
medicals I won't even consider as RFE.
Yeah,
it's simple. Give it to them.
I agree.
Yeah.
There was one question I think you might have the answer for that I might not be able to hit. Abhinav asks, am I allowed to file a current H-1B visa for home health physical therapy job?
Why not?
I would assume yes.
Yes, yeah. Physical therapist is considered to be a professional job. Home health is allowed. However, the issue with the home health is that you may have to define a geographical area. So if you get the LCA, let's say for example, you're working in Detroit, and you get the Detroit MSA, you can cover that. You're going to be working in the main locations and around that area. So as long as you're working in the Detroit MSA, I don't see any problem in it. I've seen a lot of those people getting H1s. In fact, my wife is a physical therapist. My brother-in-law is actually a physical therapist in Detroit, and my sister-in-law too. So a lot of people who are physical therapists. Yes, some of them do home health. Yeah, you can get the H1B on that.
Arzu from Facebook asks or states, my perm was filed on April 21st, 2022. It's still in progress. Looks like the DOL has tons of delays. Asked for any suggestions. What I'm seeing come across my desk right now is perms that were approved in January and February 2022. And so that said, I would tell you 4 to 8 weeks maybe is what you're expecting to get that perm approval. We haven't seen the delays going out. If anything, we're seeing the delays get a little bit better. But given just what I'm seeing anecdotally, I would say you're 6 to 8 weeks away, roughly, from your perm approval.
What do you mean delays getting better?
For a while, it was taking close to a year, right, to get perm approvals through USCIS. Right now, I would say roughly 8 months, give or take. But routinely, the perm approvals that I'm seeing right now, they're coming from late January, early February 2022. So you're pretty close there, Arzu. And I'll hop in another one, Rahul. Patrick from the YouTube asks, I responded to an EB2 NIW RFE about 2.5 months ago. I still don't have a decision from the U.S. officer. When can I follow up? Priority date is January 2022. Typically, USCIS will allow you to put in a service request after 60 days. So, once you sent the thing.
But it says EB2 NIW, so it means I-140. You can do premium processing.
Not yet. On that, that's a good point.
Okay.
And so first thing that you can do is you can raise a service request. Google USCIS service request, and if you're an NIW guy or girl, you can figure out how to put in that service request. It's a self-petition, so you can likely put it in yourself. You don't need your attorney to have done it, or if you did have an employer sponsor, you should be able to do that yourself. Now, to Rahul's point about the premium processing, is there premium processing for EB2 NIWs? Yes, with an asterisk. The asterisk being that USCIS is going to tell you when you can file the EB2 NIW premium processing upgrade. Right now, off the top of my head, I'm not going to be accurate. I would say it's probably going to be August 2021, roughly. Generally, it's going to be they want to see it processing for about a year before they're going to give you that entitlement to bump it up to premium. So is there premium available? Yes. Right now, no. So do the two things. One, put in a service request. They might tell you, hey, it's within the normal processing time. And that's, I would tell you, 85% likely. Wait a little bit longer, and if you want to spend the extra $2,500, do the premium processing upgrade, and you'll have your answer within about 2 weeks.
The question from Rajesh, and this needs a debate between you and me. His question is that if he relocates from one office to another office, does the company needs to file a labor and I-140 again is the question.
Okay. That's a multifaceted question, but what I would say is if they're moving offices.
Well, no, he is moving, the offices are there. Mm-hmm. So one office is in Atlanta, one office is in California. Mm-hmm. He is moving from California to Atlanta. Mm-hmm. But the offices are still there in California.
On the I-140.
Yeah.
Okay. So the way I would want you to think about this is in your head, and this is the way I try to explain all green card cases to my clients, is that this is a future job opportunity. And you're not going to be taking this future job opportunity until the government tells you that you can. When I say tells you that you can, I mean approves the 485. And so when you're filing the I-140, when you're filing the 485, what you're saying is it's my intent today to go work in that position tomorrow. And so wherever I'm at physically today has no bearing on that intent. So if I'm today in, I forget your cities, but say I'm in Atlanta and I'm going to move out to California, that's completely fine. Come the 485 stage, however, I need to be willing and ready to tell the government that I'm going to go work in that Atlanta job. It's the intent, right? It's not actual. It's what am I intending to do today? Your intent is allowed to change, that's of course, but that is what you were saying on the 140 and all that. I'm eventually going to go work there. And so if you're going to go work on your H-1B up in Michigan, hey, it's not a problem at all. If you're going to go work for that other office for the same company in California, no issues there. Same logic.
What about with the consulting companies? People move on from one place to another place. Then what will happen at that time?
I would say that's 99.9%, and it would be an attorney's gross mistake if they're doing a perm for a consulting company to not put the golden word, will work in unanticipated locations. And so if you're a consulting company, let's say they're in Houston, they're going to run their perm in Houston, but they're going to put the magic words in the perm, will work in unanticipated locations. That means you can work in Washington, D.C., you can work in Washington State, you can probably even work in Puerto Rico.
They never have intention to come back to Houston. It's still okay for them.
The perm allows you to work in any unanticipated location. So the idea is once you get your green card, you're still going to continue the consulting. So you're not going to go work at Rahul Reddy's office in Houston, Texas. You're going to go work at the end client location for Exxon in New York City. You're going to go work for Citibank in Los Angeles. You're going to be at these end client sites. So when it's in the consulting, if you have that golden language, will work in unanticipated locations, I would tell you across the board, you really have nothing to worry about.
Pramod has this question: can we go to B1 or B2 or F1 when layoff happen to H1B person? Yes, you can, but you may want to consider the compelling circumstances EAD. Please watch the last week video Ryan has made on very good presentation on that, and he will give a free evaluation if you fill the Google sheet out. So please watch that. You can go to B1 and B2. You can go to F1. But then to convert from there is a big deal. You may have to go outside the country and come back. You may as well consider, if you qualify for it, into compelling circumstances EAD. Because on B1, B2 you cannot work, and F1 you cannot work, but on the compelling circumstances EAD you can work. So please watch the video.
And we have one question, and Rahul, I'd like your insight on this one too, from Pranathi on YouTube. It asked, are you seeing any 485 approvals from the National Benefit Center? What I'm seeing, I would say 99% are coming from the NBC. That's even when people go to the field office for the interview. After that interview, the officer sends it back to the NBC where we see the approvals. I don't know if you're seeing them.
A lot of approvals. In fact, today itself we saw a lot of approvals because 4 days we are off. 3 days we are off. We saw a lot of approvals today too. If your priority date is 2010, and if your filing date is July 1st, 2022, that's too early though. But we are seeing approvals coming in very fast. July 2022 is only like 6 months, about 6-7 months. I would recommend to wait at least 4 or 5 months for you to get an approval. That's what the timing that we are looking at. Since your priority date is current, you should be fine in getting the green card.
Thops asked on YouTube, got the green card, but still didn't transfer to the location on the perm. The same employer, just hasn't gone to that location. Is there any issues? My opinion is that you have the green card. You can go work for any employer in any location of your choosing. I always say you can go be the CEO of Tesla, which Tesla shareholders might want right now, new CEO, or you can go work at the front desk of McDonald's, and you can do anything in between. And so if you've got the GC, Thops, don't worry anymore. And even when it comes to the citizenship stage, no worries at all. You've got the GC, you've done everything correct up to that point, and from what you're telling me, you're doing everything correct from that point. And so for me, nothing to worry about.
Oh, Sri has a very interesting question, Ryan. Do you have millions and millions of dollars with you?
I don't think I'd be showing up for work on Monday if I had millions and millions of dollars.
He says that, don't you guys lose money if the per country limit is being taken off? First of all, we don't make millions and millions of dollars. I wish we are. I said, we're going to miss Ryan, and probably I'm not going to be working too if I get that. We would make millions of dollars if the per country limit is being taken off. Why? Well, here's a simple reason though. We have enough clients right now. All we do is that if we increase the amount of money we charge by about 30 to 40%, our margin will go up very much time. And people don't care. If they get the green card in 1.5 to 2 years, they don't mind paying double the fees. I guarantee that. I bet on it. I challenge to 95% of the people. If I tell any Indian right now, you're going to get the green card in 2 years, will you pay me double the fees? I would say 98% of them will say, no, Rahul, only triple. That's what they would say. So don't worry about our money, Sri. We don't make millions of dollars, so that we lose millions of dollars. If per country limit is being taken off, there's a good chance I may make $1 million in a year. Because as I said, they don't care about the fees. If I tell them, I will give you a green card in 3 years or 2 years, double the fees, they'll say, no, Rahul, only triple the fees. This will happen. And I'm pretty sure I was there before. I didn't care about the money at that point of time, as long as I got the green card faster, which I got it. But right now, if I tell the people, okay, you have to pay the money for the H-1B, you have to pay the money for this one, and I have to extend it, everything is a negotiation for us, which seems to be, I mean, they can't, you have to sustain the immigration lawyer for 10 years. Well, that's not how I would like to. I charge double the money, get you the green card. People will be happy to pay. Maybe you don't want to pay, but I would say that most of our clients will be willing to pay double the money if I just tell them, I'll give you the green card in 2 years. Most of my clients, if not all of my clients. Maybe Sri, you won't be willing to pay double the money for me if I give you the green card in 2 years, but then you will be an exception. I will make millions if the per country cap is being removed, but it should legally be removed. It should morally is illegal. That should be removed.
And just to that point, think of this: all this backlog of people who are waiting to file their green cards. Those people turn into dollar signs, and I don't like to talk like that. But to your point, Sri, if there is this big change, there's still the queue that exists. The business doesn't change.
Yeah, the queue will always be there. The only thing is that it's going to move pretty quickly. That's better.
That was a good chat. I had a good laugh. So, issue here. Where was it? I lost it. Okay, here we go. From Dharmal on YouTube asks, is it normal for lawyers to request consular processing on the I-140, even though the person is still in the U.S. as a backdrop? I wouldn't say it's a norm, but I might even go so far as to say it's the smartest step. I might not take that step. Ultimately, if you're putting consular processing on the form, it doesn't impact your ability to file your 485 domestically or not. There are some instances where I might put consular processing on the forms as a matter of course. If you're an F student, I would likely put consular processing. If you're on TN, I'm almost always going to put consular processing. Or if, simply put, you went home for a vacation on the day that I filed your I-140, your body is outside the United States, I'm going to put consular processing because that's the most truthful statement on that day. And so, is it the norm? I wouldn't go so far as to say that. Is it abnormal? Not at all. And again, like I said, I might even say that's the smartest thing to do because ultimately it doesn't have an impact in the end.
Ganesh Venkateshan has this question. The rest of the world backlog is growing up. What are the possibilities that they will remove the per country limit from the GC? Ganesh, if there is any possibility to remove the likely possibility to remove the per country cap is only available until January 3rd. After that, it's not going to happen. It's not going to happen. Then maybe 2 years down the line, which is 2024 December, is the time that we may see there may be some consideration of the removal per country, because it was the Republican Senate, it was the Republican House that actually voted for removing the per country cap. Never to forget about that. So it may happen. If it happens, that will be the December of 2024. If it doesn't happen in the next 3-4 days, which seems to be very unlikely because the proponents of the per country cap, they try to push in. It seems that Joe Lofgren, who is the master for all these architectural things, what she did it for a removal of the per country limit. She didn't felt that she has enough votes to pass in the House. There was a black caucus, which part of it, as some Democrat people have opposed this bill. So none of the Republicans have supported this per country cap removal as compared to the last Congress. So she backed off from the voting. So that seems to be very unlikely at this point of time. So we still have hope for a week, but I don't know where to hit the doors, because I don't know if anybody knows where to hit the doors. You can let me know. But right now, it doesn't look like we can get that thing accomplished. But what I would, if the things don't get passed in the next 1 week, Ganesh, there's a different program that I will start focusing on, especially starting from next week or so, would be that let's try to go to the administration. Can the administration do some things to reduce the waiting period without going to the Congress, which is in the parliament is called Congress in the United States? Yes, there are possibilities, and that's what we want to suggest the administration. One thing is to not count the family members. The INA regulations, the INA Congress legislation doesn't say to count the family members or not count the family members. They are counting the family members. If the administration unilaterally take the decision, okay, we'll not start the family members, then the numbers will go on from 140,000 to 300,000 green cards every year. That's pretty much enough for us. We won't need anything more than that with the demand that we have right now. So that will completely wipe out to a greater extent, the waiting period for the Indian nationals to get the green card. That's one thing. They also wasted about 300,000 green cards in the past 15, 20 years, 25 years, 300 plus thousand green cards. If they bring those green cards and then give it to the people again, though, without going to the Congress, that's 600,000 extra green cards. We don't have the waiting of more than 900,000 people waiting the green card. So if they can wipe out that in just 1 year, the administration can do. But we'll start the process from next week because we still have the Congress fighting for it. So it's not the right time for us to go.
Pramod asks, and we give you our thoughts. You slipped on some snow and you had surgery while you were on H-1B. Then asked, does the H-1B guy get any support for GC processing on human grounds? Yes and no. 95% no. Now, what can you do on humanitarian grounds to maybe break off of the H-1B? These compelling circumstance EADs, they have very limited uses, and if you are interested in that, you do really want to talk to an attorney to make sure that you're completely understanding what you're getting into. So there is methods to where you can jump off the H-1B, get a work authorization on these humanitarian grounds, but that's not going to give you necessarily a jump into the green card. And so to answer your question, is there any support for green card processing on humanitarian grounds? Unless you have a pending 485 and your priority is current and there is some urgent humanitarian need, they're not going to bump you to the stack. If you're still waiting on your priority to even come current, there's nothing for you other than maybe these I-140 compelling circumstance EADs. But again, if you're interested in that, it really is important to make sure you talk to an attorney to understand what it is that you're getting into, and not necessarily the consequences, but the things that you're going to need to do on the back end to realize that green card.
Ari Lenz has this question. Is there any bipartisan effort to do anything to do with the documented dreamers? And what is the impact on these anti-H-1B groups on the legislation? Well, they do have a lot of influence, the anti-H-1B group. They do have a lot of influence. So definitely they have influenced it. They were able to knock out the removal of the per country cap. They are able to not include the documented dreamers thing in the budget legislation. They are winning right now at this point of time. We, those people who want to take the discrimination off, we have to get united, and we have to be more inclusive. Okay, I don't like this guy. I hate lawyers. I hate doctors. I hate congressmen. I hate senators. But pass the legislation. No, that's not how it's going to happen, though. We have to try to convince the other group. We need to debate with them. We need to discuss with them. They have a comprehension. They think that high-tech workers are low-paid workers. You see the W-2 forms every day.
They're not low-paid workers.
Yeah, they are not low-paid workers. I don't know where they get these low-paid workers. What do you mean low-paid workers, guys? We know what you guys get paid. One of the guy was telling millions of, we don't. We see you guys making millions and millions of dollars. Happy for us. I mean, we are very happy that you're making that money. But we need to show your W-2 forms to these people. Maybe you should hit with this W-2 forms. What do you mean low paid? Look at my W-2 form, you dummy. I'm making 250. I'm not. You guys are. I'm making. Show it to them in the meeting. They address the H-1B workers as the low-paid tech workers. Tech workers are not low-paid. I don't know where they get this idea. So we need to give it to them. Inclusive. Go to the debates. Tell them, look, I am not low-paid worker. What do you mean? This is my salary. Am I low-paid? Look into the average salary of United States. Average family income in United States is approximately around $60,000 to $70,000. How much is your family income? Tell it to them. Give their W-2 forms. Of course, wipe out your private social security and other information. Give it to them. We need to provide. We need to debate with them. We need to argue with them. We need to win them to our side. Of course, there are some cases that we cannot win to them, but to the most extent we should try to. A lot of people ask this question: my senator, my congressman is anti-immigrant. Should I write him a letter? Yes. It doesn't mean, just because he is not on your side, you should explain your story so he will soften on his stance. To an extent, he may soften on it. If he doesn't, what are you going to lose? So yes, even if your senator or congressman is not in line with the immigration with you, you should still write the letter. Even if the people are opposing you, you should respectfully disagree with them and you should show your point. This per country cap is not to favor Indians or Chinese. This is to treat every human being equally in this country. That's the demand. Just like the way at one point of time, African Americans were not allowed to vote. In fact, Indian nationals were not allowed to become citizens of United States until 1956. They were not allowed to become. In fact, the Supreme Court decision in 1923, whoever Indians were been actually given citizenship were being taken off. They said, no, even though we gave the citizenship, we're going to cancel all the Indian nationals. And they took the citizenship out. At that point of time, the entire Indian population in USA has dropped down by 50% from 1923 to 1930. Because a lot of those Indians people used to own the land in California, where at that point of time, the law requires that you must be a US citizen to own it. When they become a US citizen, they own the land. Their land has been taken off. Their citizenship has been taken off. Yes, we have been discriminated at that point of time. Is that discrimination is getting undone right now in this removal of the per country cap? No, it's not. We are not even trying to fight that one. All we are telling you is to treat every person equally in this per country cap. So these people are telling it's favoring some countries. It's not favoring any country. It's just treating everybody equal. Why, if somebody is a talented person, why do we look into which country they came in? If they're talented, they're talented. Do we look into, if Michael Jordan or whoever the person is, if he's a good player, he's a good player. Why should you care which country he comes into? Yes, you want to put the number of immigrants that are allowed. Okay, that makes sense. But why are you telling that only certain national people can come in, not the other national peoples come in? That is definitely a discrimination which we want to avoid. So we need to argue, we need to be inclusive. I know some of the organizations are very good, but I want you to take the personal responsibility. Don't believe on some of the organizations. As some people said, if the per country limit is been taken off, immigration lawyers like us won't get the money. Believe me, I'll get more money. Don't be concerned about it. And it is those people, there's one organization, I don't want to name it, if the per country code is removed, that guy actually is going to lose the job. I'm not going to lose the job. I'm going to make more money on the per country limit. Don't worry about me. Just worry about yourself. Let's try to get inclusive. Let's try to argue with these anti-H1B, anti-immigration groups and speak with them and engage them and convince them to our side.
And then one last point, you asked kind of a similar question. How do you address the viewpoint that H-1B, for me, green card workers steal American jobs? My first response is, how are they stealing it? This is an open market. If I see this guy that's better than this guy, I'm going to hire this guy. I don't care if he's an Indian or if he's an American, because my bottom line says that this guy is the better employee. I'll even throw this at you. I don't have the exact study on it. It came from the Cato Institute, which for me tends to be a little bit more right-wing. I wouldn't call them anti-immigrant, but...
Cato Institute is not right-wing.
But the statistics came out that one H-1B tends to equate to 4 to 6 American jobs created. So if anything, H-1B workers are creating American jobs rather than stealing it.
And then there is a statement which, under the penalty of perjury, the employer has to give, that by employing this person, it is not adversely affecting the U.S. workers. That's an extra thing when you hire for a H-1B. You have to post a notice for 10 days, the LCA notice. And for an American worker, you don't have to give them the prevailing wage. You can give them the minimum wage. That is approximately about $12 or $10, depending on which state you are in. So there's no need for the prevailing wage for the H-1B workers, you have to pay the prevailing wage or the actual wage, whichever is the higher. And there are a lot of limitations. And for H-1B, you have to get the approval from the Labor Department. Then you have to apply with the USCIS. The filing fees in some cases is more than $6,000. That does not include any legal fees. There are a lot of obligations. The company cannot cut down the salary of the employee lower than the prevailing wage. When it comes to the US citizens or green card holders, if the economy doesn't go good, okay, we cut down 25% of the salary to sustain the company. Yes, they can legally do it, but you can't do it with the H-1B employees. There are a lot of restrictions on those. And the only reason why people feel, we are there, why people feel they want to hire the H-1Bs, they couldn't find the US workers here. That's the reason. We don't see a lot of MBAs, other people getting H-1Bs. It's always IT workers because there's a lot of shortage in there. And we see if they don't give the jobs here, we know where the jobs are moving on. Look at where is the biggest Microsoft office other than in Washington State. It's in Hyderabad. What about Google? In Hyderabad. What about Amazon? In Hyderabad. And what about Apple? In Bangalore. So all these things are going there because they couldn't find enough workers here in the United States. And I don't know why they are crying, saying that they are taking the jobs. No, this is something that actually, as Cato Institute has rightfully pointed out, the H-1Bs are creating jobs. And thanks, it's jobs of mine and Rain also created by you guys. We are US citizens, but yes. And there are a lot of other supporting people here in our office. And thank you guys for creating jobs for us too.
Here. Akshat Jain from the YouTube asks, can I change my underlying I-140 for 485 from I-140 NIW to regular I-140 with the same employer? Priority dates December 2012. Now I'm going to assume that your 485 is pending, and so I would just ask you, why would you do that? And I don't mean that in any insulting way, but simply you've got an EB2. I'm going to assume your first I-140 is EB2. I'm going to assume your NIW is EB2. To me, that just means you have two EB2 I-140s. I'm going to assume your 485 is pending, so that means you've got a pending EB2 485. So if you're going to transfer the basis, you're just going from one EB2 to another. There's no purpose to do that. If there's maybe some background details I don't know, shoot us a link on the contact us page on reddyneumann.com. Happy to reach out, but generally I would tell you, there's nothing gained from wanting to jump from the 140 to the NIW 140. They're the same thing in my view.
Pramod has this question. Well, it's immigration. It's a little bit more personal towards lawyers. Anyone in India who studied BL or LLB, can they come here for masters in USA? Is it advisable? Is it good plan? I don't know about that. I can tell you one thing, Pramod. The person who does a law degree in India, they can directly fly into USA, take the bar exam in United States, and become a lawyer. They don't have to go to master's degree at all to become a lawyer. And a lot of people are shocked when I say this. No, Rahul, it cannot be true. Well, I am. Look at me. I did my law degree. I came here on H4. I just went to California, took an exam called bar exam, passed, became a lawyer. That's one part of it. The second part is, after I became a lawyer, I can't work because I don't have a work visa. That's a different issue. It took a little bit while for me to get an EAD through my wife, and I came married, but to the adjustment of status. Yes, they can directly become a lawyer, but can people come on a master's degree in USA on F1? Yes, Pramod, that's possible. I did my LLM after I became a lawyer, though, not before I became a lawyer. But a lot of people who come here on an LLB degree, they come here and they do the master's, then they eventually become lawyers. In my case, since I was already married, came on H4 as a dependent, was doing cooking for a while, I was husband, and then wrote the bar exam and became a lawyer, then went on and did the master's. I did everything the reverse way. But yes, people can come here on a master's degree and have F1 and then complete their master's degree. They will only be given a work permit of 1 year because master's in law is not a STEM degree. They're not going to get a work permit for 3 years, so that's a deficiency there. There's also a master's degree is 1 year. LLM master's is only 1 year. It's not 2 years. So that's another thing that you noted. So if the people are prepared to come do the masters, yeah, they can. There are other things to be considered, but you can always, you don't have to consult me privately, but send an email. I would always like to speak with a person who is coming on a master's degree, have a chat with that person to see what his interests are, and I will always be mentor if they want to be.
And then I'll take one more if you'd like, Roll, before we close. Almost 6. Shahul asks, can I leave the country for, let's say, 10 years and come back when the party date is current after 6 months of the I-140 approval? I would say, yeah, you have no issues there. The I-140 doesn't expire by any length of time, and the fact that you might have left for a decade doesn't do anything to impact the validity of the I-140. Simply put, as long as the company is willing to sign the 485J or do the DS-260 to call you into the consulate, you're going to get the green card. And so if you want to leave for 10 years, that I-140 doesn't go away unless the company withdraws it. But that's a different story.
What if the company withdraws it? Can I find another company to file I-140? Can I port the date while I'm in India?
100%.
Anything else?
No, that's it, Roll.
Thank you very much for tuning in. If anybody's interested in the compelling circumstances, please watch our last week video. Thank you.
Thank you. Bye.